The audio and video is clear. Once again, this is my Telegram channel. Any doubts or queries that you have, you may ask it over here. In the last class, we had just started off with Parliament and we were basically seeing the functioning of Parliament. Parliament कैसे काम करते हैं, what is the overall quality, etc. In that, one thing what we have noticed is number of sittings has reduced, number of lawyers that has reduced, number of bills referred to committees, even that has gone down. On an average, when we look at the whole time period spent in the parliament also discussing bills, etc., that also has gone down. So overall, there is a drop in the quality of functioning of parliament. ज्यादा से ज्यादा हमें क्या देखने के लिए मिल रहा है? A theory X being demonstrated by the parliamentarians. Good afternoon, Suganya. Parliamentarians have zero interest. Most of the time, parliament is becoming a playground for playing actually what? Politics. So if structure just alone, if you create a structure like the parliament and we give them powers, etc., काफी नहीं होगा. दिलचस्पी दिखाना चाहिए पार्लियामेंटेरियन की तरफ से भी. MP should show the interest. Yes, we have to run the country properly. We should do कुछ for the देश के लिए कुछ तो करना है. That feeling they should have. When they don't have it, what is the whole point of having a big structure? So today we are going to take some more details with regard to the functioning of the parliament, after which we will be starting off with our next topic, which is Indian judiciary. First thing to understand is parliamentary privileges. Privileges क्या होता है? Privileges का मतलब है one privilege. I will tell you 3-4 incidents here. Not only parliamentary privileges, these are even, you have something called as legislative privileges. मतलब Jayalalitha, the ex-chief minister of Tamil Nadu, when she, before becoming the chief minister, when she was just an MLA, her sari was torn, hair was pulled inside the Tamil Nadu Legislative Assembly. Hear it very carefully. Chief Minister, ex-Chief Minister Jayalalitha, before she became the CM of Tamil Nadu, when she was just an MLA, inside Tamil Nadu, her hair was pulled, her sari was torn in half inside the Tamil Nadu Legislative Assembly. Number one. Number two, in the state of Kerala, current education minister, when he was in opposition, he had thrown the computer displays, that is the monitor, etc. He had thrown it down. He threw the mic down, broke a few furniture. All of this he had done. That case is still going on in Supreme Court. Again, in another state, it was found. I think it was Andhra Pradesh again. MLAs inside the Legislative Assembly were caught watching pornographic video. How are they able to do all of this? When the Women's Reservation Bill was being taken up inside the parliament for discussion, a female MP, she stood up to read it. Another male MP, what he did was that he just walked down, snatched the bill from the hands of the women MP, tore it into pieces, threw it there, walked away. ये सब ये लोग क्यों कर पा रहे हैं या फिर ये कैसे कर सकते हैं ये सब? That is parliamentary privilege. Anything said or done or any vote given or not given inside the parliament cannot be questioned in a court of law. आप इस चीजों से लेकर आप उन्हें कोर्ट में या उसके दंड दे देंगे, पनिशमेंट दे देंगे. You cannot do that. Maximum within the parliament, you can initiate disciplinary proceedings like suspending an MP or dismissing completely. That you can do. But that again, parliament only can do. Nobody else can do. So now we are going to see each one of these privileges. Similarly, we know the incident where a couple of youngsters entered into the parliament and they dropped smoke bombs there. Correct? Action was initiated against them. अब तीनों के तीन जेल में बैठकर सड़ रहा है. We know that incident also. So all of this we are going to discuss here. Clear, people? Parliamentary privilege. So whatever I have wrote in italics, like I have told you, italic font, it is just meant for your information. So let us see one by one. Parliamentary privilege refers to rights and immunities enjoyed by Parliament as an institution and MPs in their individual capacity, without which they cannot discharge their functions as entrusted upon them by the Constitution. Article 105 and Article 194 of the Indian Constitution lays down the powers, privileges and immunities of members of Parliament and state assemblies respectively. The privilege given to the members are necessary for exercising constitutional functions. According to the Constitution, the powers, privileges and immunities of Parliament and MPs are to be defined by the Parliament. No law has so far been enacted in this respect. Matlab, is there a law clearly defining what is the privilege enjoyed by an MP? No. There is no such law. What we have actually in practice is precedent. यानी कि एक काम करने का एक तरीका है, पिछले 50 या 70 साल से वही तरीका फॉलो करते आ रहा है. So let us see. In the absence of any such law, it continues to be governed by the British Parliamentary Conventions. A breach of privilege is a violation of any of the privileges of the MPs or Parliament. Among other things, any action casting reflections on MPs, Parliament or its committees could be considered breach of privilege. This may include publishing of news items, editorials or statements made in newspaper or magazine, TV interviews, or even in public speeches. Number one, freedom of speech in Parliament. This is one. So this is a general idea. Breach of privilege, all of that. We will understand this better when we look into each one of the subheadings here. First one, freedom of speech. So can a parliamentarian talk anything what they want inside the parliament? Absolutely yes. That freedom is there. But unparliamentary language cannot be used. Unparliamentary language, that is every year parliament also will decide what कुछ शब्द है पार्लियामेंट के अंदर आप इस्तेमाल नहीं कर सकते. Clear? It is the essence of democracy, as free and fearless expression of opinion is a necessity. It is not only available to the MPs but also to the non-members who have a right to speak in the House. Example, Attorney General of India. There is limitation also which is provided in Article 118 and Article 121. Like I told you, you can speak. So you know, what is it? Sometimes you would have heard of this. Maut ka saudagar. That terminology was used by MP Sonia Gandhi, if my memory serves it correct, on the Prime Minister Narendra Modi. So such statements, then immediately the speaker told, no, you have to withdraw that statement. That remarks, those remarks made against the Prime Minister will be expunged. That is unparliamentary. Getting the point? Though that means freedom of speech inside the parliament does not mean whatever comes into your mind you can talk. Getting the point here? Freedom from arrest. The members enjoy freedom from arrest in any civil case 40 days before and after the adjournment of the House, and also when the House is in session. No member can be arrested from the limits of the parliament without the permission of the House to which he or she belongs, so that there is no hindrance in performing their duties. Within the parliament's premises, arrest cannot be done. Arrest is also not possible in the civil cases. Criminal cases, arrest is possible. Clear? If the detention of any members of the parliament is made, the chairman or the speaker should be informed by their concerned authority the reason for the arrest. Exemption from attendance as witness. The members of the parliament enjoy special privileges and are exempted from attending court as a witness. They are given complete liberty to attend the House and perform their duties without any interference from the court. मतलब जब parliament is in session, you cannot ask any MP to come and say that now you are a witness, come be present in the court. Cannot be done. At the end of the session, definitely yes, MP can be summoned. That is not a problem. Minister also can be summoned. Not a problem. Not when the parliament is in session. This is again to ensure that there is smooth transaction of the business of the government. Clear? Aage. Collective privileges. The right to punish members and outsiders for breach of its privileges. Members को भी बाहर से आए हुए लोगों को भी. Members कौन है? अलग MPs. So if you remember it, I had told you this example earlier also. That is, Smriti Irani, when she was the minister for HRD, she gave a very emotionally charged speech inside the parliament, referring into multiple documents, papers, etc. Speech ekdam first class tha. I mean, the way she pronounced, enunciated, everything was fantastic. Only problem was, some of the facts or data what she submitted in the parliament was wrong. Opposition did not take it very nicely. The opposition demanded that breach of privilege motion be initiated against Smriti Irani. Means, because in parliament, when you give a wrong data, minister hone ke khatir, that is a huge issue. How did the government react to it? They immediately changed their portfolio. From Minister of HRD straight away to Minister of Broadcasting and Information. Getting the point here? That is one example. What about outsiders? Outsiders का मतलब ये है, say let us say I am a TV reporter. I go to the parliament. I see something there. I report it. Pure objective reporting, no issues. But when the speaker says these following remarks will be expunged, means that should not be reported. In spite of that, I reported the expunged remarks there. They can issue disciplinary proceedings against me. They can, disciplinary proceedings in the sense, not disciplinary proceedings, they can basically either fine me, they can ask me to be present there, and give an explanation, demand an explanation, all of that they can do. Let us see. Parliament has the power to punish any person, whether strangers or any member of the house, for any breach or contempt of the house. When any breach is committed by the member of the house, he or she is expelled from the house. Not necessary. Expulsion will depend upon the nature of the, wrongdoing committed by the member. Depending on the gravity only, this decision is taken. This right has been defined as keystone of parliamentary privilege because without this power, the House can suffer contempt and breach and is very necessary to safeguard its authority and discharge its functions. अगर ये right नहीं है, collective privilege right नहीं है, तो what is the problem? MPs can basically talk any nonsense inside parliament. Outsiders also can talk any nonsense about the parliament and the members there. Correct? Parliament के एक sanctity होता है which has to be protected. So to ensure that members behave, outsiders behave, you have what? Collective privilege. आगे. Right to prohibit the publication of proceedings. If any expunged proceedings are published or any misrepresentation or misreporting is found, it is held to be the breach of privilege and contempt of the House. Protection is only granted if it reflects true proceedings of the House. Like I told you, expunging a remark means इसे हटा दो official record से. What this MP said, remove it from there. It shouldn't come in the official record. और जो official record में नहीं है, वो हम बाहर publish भी नहीं कर सकते. Simple. Right to exclude strangers. The members of the House have the power and right to exclude strangers who are not members of the House from the proceedings. This right is very essential for securing free and fair discussion in the House. Thanks to those three monkeys who actually went into the parliament and crossed that very big security breach, अब क्या हुआ है? It has become very difficult to even visit the parliament. Multiple layers of security, detailed scrutiny, all additional measures have been kept in place to ensure that this incident, what took place, will never get repeated. आगे. the right to regulate the internal affairs of the House. Under Article 118 of the Constitution, the House have been empowered to conduct its regulation for proceedings and cannot be challenged in the court of law on the ground that the House is not in accordance with the rules made under Article 18. They can deviate or change the rule any time accordingly. मतलब क्या है? Article 118 के जरिए the House can conduct its affairs however they consider it to be fit. This cannot be questioned even by a court of law. Otherwise also, judiciary cannot interfere in any matter that happens inside the parliament. That is the reality. Just like how parliament cannot discuss matters of judiciary, judiciary cannot discuss matters of parliament. So judiciary has been kept out of it, parliament has been kept out of judiciary also. Punishment for breach of privilege or contempt, imprisonment, imposing fine, prosecuting the offenders, punishment to the members of parliament. Cases of parliamentary privileges. Again, we need to discuss with examples only. So let us see. In 1967, two people were held to be in contempt of Rajya Sabha for having thrown leaflets from the visitors gallery. Leaflets means small pamphlets like that. In 1983, one person was held in breach for shouting slogans and throwing chappals from the visitors gallery. In 2008, an editor of an Urdu weekly referred to the deputy chairman of Rajya Sabha as a coward, attributing motives to a decision taken by him. In 2011, several MPs have given breach of privilege notices against actor Om Puri and ex-policewoman Kiran Bedi for using derogatory and defamatory language against members of parliament. Again, this was during that whole 2G spectrum scam and all that. Clear? Congress moved breach of privilege motion in both houses of the parliament against Narendra Modi for providing wrong information about Rafale deal to the Supreme Court. A counter breach of privilege was filed against Rahul Gandhi for misleading the House with regard to the Rafale deal. 4 MPs moved breach of privilege motion against Rahul Gandhi MP for asking to observe a 2-minute silence without seeking the speaker's permission. So that is the other interesting thing. Rahul Gandhi suddenly stood up and he basically told that let us all observe a 2-minute silence. Ultimately, you could be the opposition leader or you could be the opposition, whatever it is, or even from ruling party. Once inside the Lok Sabha, you are supposed to take the permission of speaker before doing anything. Congress MP moved breach of privilege against Finance Minister Nirmala Sitharaman for calling Rahul Gandhi the doomsday man of India. Aage. Expulsion of MPs. So that is what breach of privilege, etc. is. Till now, a single question has not come on it. Expulsion of MPs, why we are going to discuss is two things again. A little old from current affair perspective. But here again, two people we need to discuss. One is obviously Rahul Gandhi. All right. Then we also have to talk about our Mitra MP. So both these things we are going to, not Mitra, Mohammed Moitra MP. So this context we will see what is the difference between the two. So first, in 2005, 12 MPs, 11 from Lok Sabha and 1 from Rajya Sabha were expelled from the parliament allegedly for accepting cash in exchange for raising questions in parliament. In a 4-1 verdict, the apex court upheld the expulsion of MPs on the basis of Article 105 and called it a self-protection exercise by the parliament. So parliament itself expelled around 12 MPs. On what ground? That they took money for what? For asking a particular set of questions in the parliament. Supreme Court upheld it and told that it is a self-cleaning exercise. A 5-judge bench led by Chief Justice Y.K. Sabharwal also added that the judicature is not prevented from scrutinizing the validity of the action of the legislature trespassing on the fundamental rights conferred on the citizens. The judicial review of the manner of exercise of the power of contempt or privilege does not mean the said jurisdiction is being usurped by the judicature. Means what? I already told you judiciary cannot interfere in matters of the parliament. Then how is it that this here again judiciary is interfering? It is not interference. What judiciary will only look into is, was the relevant procedure followed or not? पार्लियामेंट में एक्सपल्शन करने के लिए भी एक प्रोसीजर है. So was the procedure followed in the correct format or not? They are not going to look into the merits of the case. Parliament can decide whether or not an MP can be expelled or not. उसका merit या demerit ये सब कौन तय करेगा? पार्लियामेंट ही करेगा. लेकिन तरीका जो है, एक्सपेल करने का तरीका जो है, क्या वो कानून के हिसाब से या कॉन्स्टिट्यूशन के हिसाब से हुआ है या नहीं? That thing judiciary will look into. Clear, people? The Supreme Court mentioned the third clause of Article 105, which says, in other respects, the power, privileges and immunities of each house of parliament and of the members and the committees of each house shall be such as may from time to time be defined by parliament by law, and until so defined shall be those of that house and of its members and committees immediately before the coming into force of section 15 of the Constitution, 44th Amendment Act 1978. यानी कि whatever be the powers, privileges या फिर immunity जो भी है पार्लियामेंट के हर एक मेंबर का, इसका अंतिम फैसला कौन करेगा? पार्लियामेंट. कैसे? कोई भी कानून के जरिए. And if parliament has not passed any such law, then whatever is the convention, whatever is the established practice, that will be followed. This is what Supreme Court ruled. Aage. The Supreme Court made it clear in its verdict that there is no basis to claim absolute immunity to the parliamentary proceedings in Article 105, Clause 3 of the Constitution. The manner of enforcement of privilege by the legislature can result in judicial scrutiny, though subject to the restrictions contained in the other constitutional provisions, for example, Article 122 or 212. मतलब वही चीज है. Parliament court can scrutinize whether the process is followed in the rightful manner as per convention or as per any rule or law. The court also added that the truth or correctness of the material relied upon by the legislature for taking action will not be questioned by the court, nor will it go into the adequacy of the material or substitute its opinion for that of the legislature. मतलब आपने ये क्या किया? 12 MPs को आपने क्यों निकाल दिया? Court is not going to question that. सबूत क्या है आपके पास? दिखाओ मुझे. That also court is not going to look. Court will only look whether the process has been followed. Whether those MPs also, as per the parliamentary convention, MPs को क्या मौका दे दिया था explanation देने के लिए? Court will only look into that. आगे. The cash for query case against Mahua Moitra was handed over to the Lok Sabha Ethics Committee. The committee conducted the inquiry into the matter as per the rules. During the investigation, Ethics Committee panel questioned Moitra and other parties in the case. The committee held Moitra guilty and recommended her expulsion from the Lok Sabha. The recommendations of the committee were presented in the form of a report as the rules suggest. The case against Mahua Moitra was very, very simple. That is, every parliamentarian, every MP will be having an official ID and password for accessing the parliament's website. Asking questions, all of that. They'll be giving an ID and password. It is clearly told to them that you should not share it with anybody else. Keep it very confidential. But again, it is a public secret that sometimes MPs will share it with other people. For XYZ reason. Sometimes they share. Not all, but few at least will share. And it's been happening since a very long time. How Mahua Moitra got caught up in this was almost with around 1 or 2 hours gap. Her using her login ID and her password. three different sets of people accessed her account. One was sitting in Bangalore, the other was sitting in Delhi, the other one was sitting in Dubai. Now these are all not very near places. Even if you travel in helicopter from flight to flight also, within a span of 1 hour in three different places, how are you going to access, from three different places, how are you going to access her ID or account? This was caught, number one. Then there in the ethics committee, they basically were able to prove that yes, she admitted also that she had given it to her friend. So ethics committee concluded that she is guilty of, sharing the password, which again means what? You have broken the law of the parliament, because initially itself when you become an MP, you have agreed, yes, I will not share this with anybody. You have agreed to it. Now now when you have shared it, obviously parliament has to take action. So she appeared in front of whom? She appeared in front of the Lok Sabha Ethics Committee, who conducted an inquiry, and finally they submitted a report. The report by the Ethics Committee is presented to the Speaker, who may direct that the report be laid on the table of the House. After the report has been presented, the chairperson or any member of the committee or any other member may move that report to be taken into consideration, whereupon the Speaker may put the question to the House. Parliamentary Affairs Minister Prahlad Joshi moved a motion to expel the TMC leader for unethical conduct. Before putting the question to the House, the Speaker may permit a debate on the motion not exceeding half an hour in duration. Matlab, report came to the Speaker. Then anybody from that committee, that is which committee? Ethics Committee. Who can it be? Either the chairperson or any member of the committee or any other member of the parliament may move that the report be taken into consideration. That is, let us discuss it. Speaker can basically give time also to debate over it. And ultimately, Parliamentary Affairs Minister Prahlad Joshi basically moved a motion. He made a motion telling that it is time to expel the TMC leader for unethical conduct. After the motion made under the sub-rule 1 is agreed to, any member may move that the House agrees or disagrees or agrees with amendments with the recommendations contained in the report. The Lok Sabha in its document says, the panel recommends any punitive action, a motion is brought to the House based on the proposal and it is voted upon. Matlab, itna hi hai. That is, after the motion is made under sub-rule 1, what motion? Removal motion is made. Then House agrees or disagrees with whatever amendments that they found based on the report, whether they agree with the report, whether they want to make any changes to the report, everything is suggested. And finally, the motion is put for vote. What is the motion? The removal motion. And then decision is taken. So in Mahua Moitra's case also, when she took it up to the Supreme Court also, Supreme Court only looked into what? Whether the process of expelling Mahua Moitra was conducted as per parliamentary convention. It was followed through and through. Court did not bother to interfere. She was expelled. Clear? Rahul Gandhi was disqualified as the Lok Sabha MP following his conviction in a defamation case. A comment given by him where he basically made a very loose statement saying that why are that all the thieves are having Modi's surname. He made a loose statement, whatever it is. See, many loose statements are made by many politicians. But this particular loose statement made by him was considered to be offensive by the Modi community. They put up a case against him. The court ruled against Rahul Gandhi. And because it was a punishment where he could get jail term of at least 6 years, by default, he became disqualified. That is once. That is, if let us say I'm an MP. And if I've been convicted in a case for 6 saal, by default, I become disqualified to be an MP anymore. So, Rahul Gandhi's case was one of disqualification. That is, Parliament ne kuch nahi kiya tha. It was based on a court order that he became disqualified. Moitra's case is not about disqualification but removal. In Moitra's case, there is no offense committed under the Indian Penal Code, which is why the matter was referred to the Ethics Committee. Moitra was expelled following a voice vote in the House, and Rahul Gandhi was disqualified after the Lok Sabha Secretariat issued a notice to him informing the same. So Rahul Gandhi's case was directly based on what? A judicial ruling. Court has ruled like this. So based on this court ruling, we are disqualifying you as an MP. They sent the notice to him. Mahua Moitra's case was not about breaking any law of the land. It was about a breach of ethics, ethical guidelines or ethical principles of the parliament. It was put over vote, and based on the voice vote, she was removed. Provision for suspension of members is given in Rule 374 and Rule 374A of the Lok Sabha rules for the Lok Sabha and Rule 256 of the Rajya Sabha rules for Rajya Sabha. As per the rules, the Speaker or Chairman, as the case may be, may name any member to be suspended in case of willful disregard for the rules of the House or causing disruption in conducting sessions. After naming, a motion to that effect is removed and that member is suspended for a period not exceeding the remaining days of that session. What do you mean by suspension? Suspension simply means, say for example, budget session is going on. And I am an MP in the parliament. I am going on jumping and shouting slogans, doing this, that, etc., constantly disrupting the parliamentary proceedings. Speaker can suspend me. Sometimes it will be for one day. Sometimes it can be for the rest of the session. It can be anything. It can be anywhere for 1 hour till the end of the session. They can remove me from there. While the Privileges Committee looks into complaints raised by MPs against officials, media, or other MPs, the Ethics Panel is the only committee that probes the layperson's complaints against lawmakers of the Lok Sabha. Getting the point here. Privileges Committee, when we talk about, looks into complaints raised by MPs against whom? Outsiders, officials, media, or any other MPs also. Ethics Panel looks into the ethical conduct of MPs inside the Lok Sabha. Okay. Articles 105 and 194 of the Constitution deal with privileges. These articles maintain that the rules and regulations which would govern the privileges, including breach of privilege, shall be determined by Parliament. Parliament or the State Legislative Assembly has the power to lay down such regulations, which would also provide for the various privileges, breach of such privilege, and the punishment for the breach of that privilege, which can be imposed. In simple terms, इस मतलब सिर्फ इतना है, Parliament can decide प्रिविलेज क्या होता है, ब्रीच ऑफ प्रिविलेज क्या होता है. पार्लियामेंट अगर चाहे तो इसके लिए कानून ला सकते हैं. सेम थिंग अप्लाइज फॉर स्टेट लेजिस्लेटिव असेंबलीज ऑल्सो. I can bring a common guideline and say, these are the do's, these are the don'ts. Clear, people? Good afternoon, Abhinav. Any doubts so far? Any doubts? Moving on, parliamentary committees. Parliamentary committees increase the efficiency and expertise of parliament. Now, what is parliamentary committee again? Simple. Now, let us say there is a Waqf board bill referred to the parliamentary committee. Why did we refer to it? Because the original bill that was proposed by the central government had a lot of controversial clause. So, we referred it to a committee to get the issues sorted out and then get it back. Yesterday's class, we already saw number of bills being referred to committees have declined drastically. So parliamentary committees' purpose is to give an expert advice, to guide the parliament, to guide the lawmakers into framing sensible, applicable rules and laws. ताकि बाद में कानून बनाने के बाद Supreme Court should not say, no, this is unconstitutional. This is against a constitution. I'm striking it down. That shouldn't be the case. So let us see now parliamentary committees. Increase the efficiency and expertise of parliament. Given the volume of work and the limited time at their disposal, legislators are unable to scrutinize every matter in detail on the floor of the House. Some of this work is entrusted to committees, which are composed of groups of members of parliament. These committees review proposed laws, oversee activities of the executive branch, and scrutinize government expenditure. Their reports allow for informed debate in parliament. That is the point. 3-4 MPs, let us say Abhinav, Suganya, me, 3 MPs milkar, they will sit together, they will discuss about it, they will discuss each clause, what is the problem there, what is the advantage, disadvantage, all this can happen there. Now, what is the biggest advantage here? Abhinav could be from Congress, Suganya could be from BJP, I could be an independent member. But when all the 3 of us sit together, we are not bound by the party whip. अरे party whip अगर सुनेगा तो सुनने वाला नहीं है. So even if I'm an independent member and I found, okay, whatever points Suganya told has merit, I can agree with her, I can disagree with her, I can agree with Abhinav, disagree with Abhinav, no issues. I will not face any action. Because we are only discussing a particular bill there, its clauses, its pros, its cons. Clear? And why are we doing it? Because normally MPs or ministers will not have time to literally evaluate what are the pros and cons of each decision that they are going to make. So it will be easier if it is given to a third party, that is to the parliamentary committees here, to understand or to basically find out कि हो क्या रहा है. Clear? Committees also provide a forum to build consensus across party lines, help develop expertise in subjects, and enable consultation with independent experts and stakeholders. For example, the Committee on Health and Family Welfare studied the Surrogacy Bill 2016, which prohibits commercial surrogacy but allows altruistic surrogacy. As MPs come from varying backgrounds, they may not have had the expertise to understand the details around surrogacy, such as fertility issues, abortion, and regulation of surrogacy clinics, among others. The committee called upon a range of stakeholders, including the National Commission for Women, doctors, and government officials, to better their understanding of the issues before finalizing their report. This is what we call participative management. Getting the point here, people? Clear? That is, see, surrogacy and its clause. Surrogacy bill was very simple. Surrogacy simply means earlier, you would have seen that movie, Kirti Sanon's movie and all you would have seen. Earlier, foreigners will come here. If they want to have babies, they'll just target the poor households in the country where women are in need of money. So they will easily pay them some 15 to 30 lakhs they are ready to pay. They will pay and they will, what is it, get impregnated surgically, that is artificial insemination. Just like artificial insemination, their semen will be injected into their uterus. The females will become pregnant. They will deliver the baby. Baby will be taken by the foreign couple and they will go abroad. They will go back to their home country. This is how it was happening in India. India had unofficially become the surrogacy capital for the world. Bache chahiye, India jao. Many women were ready. But what was the sad part here? The sad part was that, see, ultimately, 9 months you are carrying a baby, you will end up building bond with it. To the point where not just foreigners, even it is being said that the many celebrities are indulging in surrogate pregnancy. There are rumors again with regard to Amir Khan, Salman Khan, Shah Rukh Khan, etc. that their latest children, whatever children they had in this last few years back, all are surrogate products and that. But we don't know what is the reality behind it. Rumors are there. Now, child is born. They will take it and go. Fine. That is not even the issue. The issue is sometimes the mother may die. Issue is sometimes the child may die. Another issue is sometimes the child is born with some defect. Then the American parents will say, no, 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 we don't want a defective child. We don't want. We want a completely healthy baby. Now, who will take care of the baby? Getting the picture here. So this, a lot of human rights violations were happening, and finally, government was like, enough is enough. They brought in the surrogacy bill. Where today, if, let us say I am a woman, okay, I already have 3 healthy children. But my sister or my daughter or some of my cousin, relative, somebody does not have children and they are struggling to have a kid. I can become a surrogate for that lady. I can become a surrogate for that lady. That means surrogacy bill basically tells that today surrogacy should be altruistic in nature. Altruistic means no financial gain. That means it has to be the person who is ready to be the surrogate mother should be somebody within the family. Why did the government put that clause? So that the child also, when the child grows up, finally knows who gave birth to him or her and who has taken care of him or her. So it will not cause any psychological shock for the child also. That is the reason. But government, how did the government arrive at such a big conclusion? How did they come to this fine, fantastic idea? By discussing it with relevant players involved. Government themselves couldn't have come up with this idea if they hadn't discussed it with the experts of the field. Clear? Committees also provide a forum for building consensus across political parties. The proceedings of the House during sessions are televised and MPs are likely to stick to their party positions on most matters. Committees have closed door meetings which allows them to freely question and discuss issues and arrive at a consensus. Like I told you, budget discussion, debates, etc., which happens in the parliament, that is shown in the camera. So openly, if I support the BJP or openly if I'm supporting Congress, being an independent candidate, it can cause trouble. Ulta, when it comes to these committees, these are closed room discussions. Nobody is going to televise it. So whatever I say there, whatever I agree or disagree, nobody is going to know about it. After a committee completes its study, just give me a minute. After a committee completes its study, it publishes its report, which is laid in Parliament. These recommendations are not binding, however, they hold a lot of weight. Again, not binding. Therefore, government can easily reject it. But the fact of the matter is, committee made a finding and government doesn't take any action on it can lead to later criticism. For example, the Standing Committee on Health made several recommendations to the National Medical Commission Bill in 2017. Many of these were incorporated in the 2019 bill, including removing the provision for allowing a bridge course for Ayush practitioners. What is this bridge course? What is Ayush? Ayurveda, Yoga, Unani, Siddha, Homeopathy. Most of the time, it is a big headache for the government in the sense that government doctors, they always hate to serve rural areas. After your MBBS, everything is done, they are given rural postings first. But they generally give many reasons. Some have even gone all the way up to the Supreme Court to tell that no, I cannot serve in rural area. I'm not used to it. I don't know their culture. So I will not be able to serve them better. Giving all bizarre reasons they have given. Supreme Court has told, how did you even think that you can come with such a petition and we will entertain this? Supreme Court also did not entertain it. Supreme Court literally, other than shouting at the advocate, literally told, this is unbecoming of a doctor. So always it's a headache to get the doctors come to the rural area and serve. So what the government thought was instead, let us keep a small bridge course of 3 years or something, where Ayush practitioners are there. After they undergo this 3-year course, they will be given an MBBS degree. Ayurveda, Yoga, Unani, Siddha, Homeopathy. This was a decision taken by the government. The main reason was only simple. Rural areas, let us have Ayush people to practice. But obviously, the committee did not like it. There was a lot of pressure coming from the Doctors Association. Finally, government decided to omit it. They did not take that particular recommendation. There are 24 such departmentally related standing committees, each of which oversees a set of ministries, which you would have already seen in your polity. DRSCs was set up first in 93 to ensure Parliament could keep with the growing complexity of governance. These are permanent committees that are reconstituted every year. They consist of 21 members from Lok Sabha and 10 members from Rajya Sabha and are headed by a chairperson. The DRSCs primarily look at three things: bills, budgets, subject-specific issues for examination. Standing committees can be broadly categorized into four types: subject, financial, accountability, administrative. Parliament may also form ad hoc committees from time to time. For instance, the Jan Vishwas Amendment of Provisions Bill 2022 was referred to a joint parliamentary committee, which is an ad hoc committee. Ad hoc committee का मतलब है as on were basis you form it. यानी कि अगर जरूरत है तो बनाएंगे, जब जरूरत खत्म है तो डिसबैंड कर देंगे. क्लियर? आगे. Such committees are disbanded after submitting the report. Department related committees or subject committees ensure oversight over each ministry. A minister is not eligible to be a member. There are 24 subject committees and each committee has 31 members, with 21 from Lok Sabha and 10 from Rajya Sabha. Membership in committees is allocated to parties in proportion to their strength in the House. Subject committees review proposed laws, select subject for closer examination and scrutinize the allocated budget for each ministry. All are just hardcore polity. That is why I'm just reading it out. Because like I have told you infinite number of times, directly ऐसा सवाल आएगा, chances are very, very less. Always it will be from an analytical angle कि सब committees के साथ हो क्या रहा है, committees के तरफ क्यों कम bills refer होते जा रहा है. These will be the nature of questions that you can expect. Or in the larger scheme of things, Parliament का performance आजकल क्या हो रहा है Parliament के साथ, that also they can ask. Clear people? Moving on. To ensure proper scrutiny of bills before passage, they can be referred to a subject committee for detailed examination. Committees have contributed to improving laws passed by Parliament. For instance, the Anti-Maritime Piracy Bill 2019 mandated the death penalty if an act of piracy caused death. The Standing Committee on External Affairs noted that the Supreme Court had ruled that the mandatory death penalty violated the fundamental rights to equality and liberty. मतलब क्या है? 2019 में they tried to bring in one Anti-Maritime Piracy Bill. Piracy जानते हो ना? Basically, robbers of sea. That is who pirates are. So the Anti-Maritime Piracy Bill में they put up a clause that anybody who is caught doing piracy, they will be given capital punishment, सीधा मौत. So it was referred to a committee, and the Standing Committee on External Affairs, they basically told that Supreme Court का ruling है, mandatory death penalty cannot be given. So what can be done then? Death penalty or life imprisonment. दोनों में से एक, किसी एक. It recommended that the penalty be modified to life imprisonment or death. Parliament incorporated this change when it passed the bill. Financial committees consist of three committees: estimates, public undertakings, and public accounts. Minister is not eligible to be a member. Estimate committee examines pre-budget estimates of ministries. यानी कि बजट प्रेजेंट करने से पहले ही एस्टिमेट कमिटी विल चेक हर एक मिनिस्ट्री का डिमांड क्या है, कितना मांग रहे हैं पैसा. दैट इज देयर जॉब. आर दे डूइंग इट? नो. एस्टिमेट्स कमिटी हमेशा उनका काम, दे डू इट आफ्टर द बजट इज प्रेजेंटेड. सो व्हाट इज द होल पॉइंट? नो पॉइंट एट ऑल. Getting the point here. Estimates committee, ideally their work should start when even before the budget is placed in the Parliament. But generally, that is not how it works in India. बजट सब कुछ प्रेजेंट करने के बाद यानी कि their work is large in the nature of post-mortem. लाश होने के बाद they will do everything. The Committee on Public Undertakings examines the functioning of public undertaking, that is the PSUs. The Public Accounts Committee reviews the government spending statement approved by the Parliament. A very important committee. Why? One more reason is there. Public Account Committee को assist करने के लिए, that is Public Accounts Committee basically look into the accounts of the government. कि government क्या खर्च सही से कर रहा है, सही काम कर रहा है, कोई गलत काम किया है क्या गवर्नमेंट ने. So all these things what Public Account Committee will look. और इनके मदद के लिए basically you have what? You have CAG, Comptroller and Auditor General. तो CAG के जो reports जो है, that is utilized by PAC. And therefore, PAC becomes the most important committee compared to all the three committees. चाहे वो estimates committee हो, चाहे वो public undertaking का committee हो. Clear people? There are other committees that investigate administrative and accountability matters related to Parliament and the House's day-to-day business. These committees include the Committee on Privileges, which examines questions involving breaches of rights, privileges, and immunities enjoyed by members of Parliament. The Committee on Petitions examines complaints sent to it in the form of petitions by the public. The effectiveness of parliamentary committees is crucial to the effective functioning of Parliament. There are several areas where parliamentary committees need improvement and strengthening. इसमें कोई दिलचस्पी वाला बात नहीं है क्योंकि number of lawyers have gone down. Automatically what will happen, many of them when they read a bill, they won't even understand one word of it. नाम के graduates है majority. So when they don't understand it, automatically what happens, quality of your MP is reduced. Then MPs with criminal cases, they are increasing after every election, getting elected to the parliament. तो lawyers कम है, कम से कम आधा लोग तो criminals ही बैठे हुए हैं. Even if you put them under standing committee, what are they going to do? Even if you ask them, okay, एक कमेटी फॉर्म करो, आप तीनों बैठकर काम करो, तीनों के तीनों को कुछ मालूम नहीं है, गुंडागर्दी मालूम है, कानून क्या है मालूम नहीं है, what are they going to contribute? So rather than referring it to a committee, it is better if you don't refer only. Getting the point here? आगे analyzing the effectiveness of the committees. Referring all bills to committees. Currently, bills are not automatically referred to a committee. The decision of whether a bill should be referred to a committee depends on the decision of the speaker or chairman in consultation with the minister presenting the bill. Referring all bills to a committee would ensure that all laws go through a minimum level of parliamentary scrutiny. One thing is for sure, in parliament or in state legislative assemblies, bills are passed in a haste. यानी कि जबरदस्ती हरी बरी, as if there is no time, जल्दी करके they do it. So very less scrutiny is there, very less discussion is there, very less debate is there. Even MPs also, be it from ruling party or be it from opposition party, उन्हें खुद मालूम नहीं पड़ता है कि यार इसके अंदर का प्रोविजंस क्या है, इसका फायदा क्या है, इसका नुकसान क्या है. They have no idea. आगे. For example, the Motor Vehicles Act 1988 requires the owner of every motor vehicle to take third-party insurance, which will cover compensation awarded to any person in case of an accident. An amendment bill in 2016 capped the insurance payout at rupees 10 lakh in the case of death. The standing committee pointed out that this compensation would be awarded by the courts and does not have an upper limit. Therefore, there should be no cap on the insurance payout so that it covers the entire compensation. Parliament accepted this recommendation while passing the bill. अब ये क्या है? Motor Vehicles Act 1980 and 1988 के हिसाब से, if at all, every car should have a third-party insurance so that in the event a person dies, that person should get insurance amount. Now, what the amendment bill in 2016 said is that maximum amount that can be given in such cases is what? Rupees 10 lakh. उससे ज़्यादा नहीं. लेकिन the standing committee pointed out that compensation is decided by courts. सही बात है. In accident cases especially, court will look into who died, what is their current earning, what they could have earned in the future. ये सब what is it? मानते हुए court fixes the amount there. So the committee said that when the court is fixing the amount, why are you fixing an upper limit? Parliament accepted it, removed this upper limit ka cap, bill got passed. Good thing. During the 17th Lok Sabha until the end of the monsoon session of 2023, 17% of bills have been referred to committees. Look at that irony. Just 17%. 83% were never referred to committees. Discussing the recommendations made by the committees or specifying the reasons for rejecting certain recommendations is also not mandatory. However, discussing these details in the House could help make laws robust. Further, consulting with experts on proposed laws may help address potential gaps in legislation. True. अब recommendations हो या reasons for rejecting certain recommendations is also not mandatory. कुछ भी mandatory नहीं है कमेटी के, जहां तक कमेटी का कोई भी मामला है. लेकिन such discussions and recommendations will only make the law more strong because you are getting different viewpoints. Plus, when you consult with experts again, specialists again, you are making the law more technically strong. Clear? The National Commission to Review the Working of the Constitution noted that all bills introduced in Parliament should automatically be referred to subject committees for detailed consideration and discussion. Very important and relevant point. Automatically send it off. That is what National Commission to Review the Working of the Constitution suggested. Further, subject committees should also preview the implementation of laws passed by the Parliament in their respective subject. जो भी कानून पास कर रहा है उसे भी रिव्यू करो, वरना क्या हो जाएगा, बाद में जुडिशरी तक जाएगा, वहां पर पेंडिंग रहेगा. Then judiciary, it will be a burden on the judiciary. After passing the entire law, then the final Supreme Court will say this is unconstitutional. Best example for this will be the electoral bond scheme. पूरा हल्ला मचाकर it got passed in the Parliament, but finally it was struck down by the Supreme Court. In some parliamentary systems such as the UK, all bills other than money bills are referred to committees. Attendance of MPs. Parliamentary committees hold multiple meetings to discuss issues through deliberations among members. The participation of members in these meetings is essential for the success of the committee system. However, the attendance of MPs in committee meetings is low. In the 17th Lok Sabha as of July 2023, the average attendance for subject committees meetings was 47%. Parliament में ही they are not coming on time. Attendance is very poor. Committee के अंदर even more poor. Why? मुझे क्या मिलेगा, क्या फायदा है वहां पर जाकर कोई बिल के बारे में डिस्कस करके, मुझे कुछ मिलेगा क्या, मुझे कोई एक्स्ट्रा सैलरी मिल रहा है क्या? Nothing. So why should I go? Getting the point here. The attendance in financial committees drops further to 37%. In comparison, attendance in Parliament was 79% for the same time period. Thank God for that. Clear? So we can clearly see this is what a clear lack of No incentive. Then why should I work so hard? Getting the point here? The quorum for a committee meeting is 1/3 of the committee members, which is around 10 members for a subject committee. National Committee to Review the Working of the Constitution report noted that there was large-scale absenteeism in committee meetings. It observed instances where a single committee encompassed too many ministries. It was noted that these committees may not be able to conduct an in-depth examination of the functioning of multiple ministries. Matlab, minimum quorum is required. Quorum means what? The minimum number of members necessary to conduct a meeting, and that is 1/3. एंड कभी कभार हमेशा क्या हो जाता है, अगर 10 लोग हैं तो इसका 1/3 का मतलब क्या है, कम से कम 3 लोगों से ज्यादा होना चाहिए. 3 ऑल्सो वोंट बी देयर, हार्डली 2 पीपल विल बी देयर. देन दे विल बी लाइक ओके, हम दोनों बैठकर क्या करेंगे, चलो घर चले. दे विल गो होम. फर्स्ट थिंग. सेकंड थिंग इज व्हाट, let us say one committee is there, but 3 of them are like very active. They are discussing, okay, this bill, this clause, they are discussing. Other ministers also saw it. अरे वाह, आप लोग कर रहे हो क्यों, आप ये भी देख लो ना, ये भी देख लो ना, ये भी देख लो ना. One committee to deal with the work of all the ministries. See, maybe with 1 or 2 subjects they can be experts, but you cannot be an expert in all the field. Shortage of technical staff and experts. The role of committees includes examining selected matters in greater depth than is possible in the House and reporting any conclusions of those examinations to the House. Parliamentary committees can consult with expert witness, stakeholders, and the public to better understand complicated issues and the potential impact of policies or legislation. The National Commission to Review the Working of the Constitution recommended that funds be secured to assist these committees in conducting inquiries, holding public hearings, and collecting data. आउटसाइड से भी, बाहर से भी अगर आपको एक्सपर्ट्स की मदद लेना है, प्राइवेट फील्ड से हो, एनजीओ, सीएसओ, व्हाटएवर बी इट, you need to pay them, right? Simply you cannot call them and tell them now for national building, come, Jai Hind, Jai Bharat. That you cannot do. You have to pay them. Otherwise also you need latest technology, etc. to access data, to process it, to collate it. All that you need money for all of this, which is again not available. Again, currently technical support available to parliamentary committees is limited to a secretariat that helps with scheduling meetings and taking notes. बस एक सेक्रेटरिएट है और वो लोग क्या करते हैं, टू शेड्यूल मीटिंग्स एंड टू मेक डाउन नोट्स, ये डिस्कस हुआ है, बस. Compare that with what is happening in democracies like Canada, where the Library of Parliament provides research staff to all committees on request. Library of Parliament. So you want staff, they will give it to you. They provide background information and identify potential witnesses for the committee. Committees are free to seek additional or more specialized research help from outside the Library of Parliament. Why? Fund is there. Fund है तो कुछ भी मुमकिन है. That is the main thing. Moving forward, public transparency. Committee reports are usually made public, but the internal workings of the committee may not be transparent. As a measure of transparency, the minutes of parliamentary committee meetings are included within committee reports. However, the meetings themselves are held behind closed doors. While closed doors meetings allow for greater room to reach party consensus, they may hinder public awareness of key findings of parliamentary committee. मतलब क्या है? There is a lack of transparency. We really don't know what is happening there during those discussions. Is it completely neutral? Is it favoring one party? Is it favoring another party? जानबूझकर कोई, what is it, some clauses government has added which people will not be able to understand initially. ऐसे कुछ भी हो सकता है वहां पर. So there is a general lack of transparency when it comes to the parliamentary standing committees working. आगे, Therefore, the National Commission to Review the Working of the Constitution recommended that major reports of all parliamentary committees be discussed in Parliament, especially where there is a disagreement between any committee and the central government. In contrast, some other democracies provide live webcast of meetings. In Canada, Parliament allowed committees to broadcast their proceedings within guidelines established by the Committee on House Management in 1991. 1991 से Canada is putting up all their committee discussions online. कोई भी जाकर देख सकते हैं मीटिंग के अंदर क्या हो रहा है. That is again what our National Commission on Review of the Working of the Constitution also suggested. What the अगर कोई disagreement है between a committee and the central government, that particular report should be discussed in the Parliament. Why? So that the public will be aware of what is the main issue, committee क्यों reject किया central government के recommendation, है ना? आगे. During the COVID-19 pandemic, UK had live coverage of the Health and Social Care Committee on the country's preparedness for the pandemic. National Commission to Review the Working of the Constitution recommended certain reforms for parliamentary committees. These included the establishment of 3 new committees: Constitution Committee, Committee on National Economy, and the Committee on Legislation. Needless to say, ये recommendation, ये सिर्फ और सिर्फ recommendation ही है. No action has been taken on this. Clear? The committee noted that it may not be necessary to continue the existing committees on estimates, public undertakings, and subordinate legislation, as the topic covered by them can be covered by subject committees or the proposed committees. Recommendation has not been implemented. So, types of reports published by the subject committee. Report type: bills. DFG means demand for grants. This is topics. Then this is ATR is tabled reports. Okay. If you actually see percentage of total reports submitted, bills wise, if you see 13, 14, 4%, 2%. DFG, demand for grants, if you see 32%, 28%, 31%. Grants have gone up slightly. Topics 15, 16, 18, 13%. That is, this is the lowest. ATR 40%, 42%, 47%, 45%. Not the lowest, but still not up to the mark. So, why is it that lesser and lesser committees we are seeing? Lesser quality of MPs. MPs are not giving proper attendance. And what am I getting? Why should I, as an MP, show theory, why behavior, when I'm not getting any incentive for it? So, some incentive should be given here, or proper law should be made that every bill has to go through the committee, just like how the National Commission on to review the working of the Constitution has suggested. By default, every bill should go to a committee. By law, it should be set up that this bill will go to this. This is the subject of the bill. It will go to this committee. These will be the members of the committee. Like that, the law has to be made. Till then, referring of bills to the parliamentary committees, it is not going to improve. It is only going to decline. Clear, people? So that was it. Union government and administration. So tomorrow we will be starting off with judiciary. Clear, people? I hope you people understood it, because other than exam, basically we need the examples only. We don't largely require the theory part of it. Theory part, introduction of the answer ke liye you can write down. But largely we need the examples and linking it with what paper 1. Clear? Any other doubt you have other than this? What else can we link it with? You may ask it to me in Telegram channel. Or if I were to say, let us say, So how can we improve the functioning of the parliament? By building a better structure as suggested by classical thinkers. Build a proper law. Like I told you, bills means any bill other than money bill should go to committee. Number one. Then from human relation thinkers, what can we add? We need a steady availability of experts within the parliament. Just like the library of Canada, we need a library here so that easily, anytime we need any expert, we can easily access it. Just like that. So any thinker we can, as you can see, we can tie it up with this. All right, people. So let's